Good morning, everyone. That clock on the wall is always a little late. But my trusted computer thinks that's 9, so let's get started. Welcome to the Senate Education Committee. Let's rise, and Timothy Lang, would you say the pledge?
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our first bill is SB 219, which was recessed from last week to this week. Do we have Ian Hewitt here? Tim, do you have any more information? Have you talked to Hewitt about 219?
I thought he did too.
I thought he said he was coming in from our meeting we had.
Right,
I have nothing new,
okay.
no new emails.
Well, I guess we can wait a few minutes. I can't do the next bill until 9:15, so it's a matter of sitting here or,
Jay, do you want to recess that and we can at least use maybe 15 minutes to exec, maybe 216? Civics bill. I think
yeah, but we haven't, everybody hasn't seen the amendment yet. That's the one you have an amendment for.
And you have,
And I have an amendment for it, yes.
well, give us 15 minutes to
Yeah.
talk about.
That's true. Okay, why don't we recess that bill until later today? Okay, I guess,
Madam Chair, I move that we go into exec session for the purpose of discussing bills.
let's just do 216 because that's Ian is right here. Okay, 216. Did I have everybody say yes to the
Aye.
executive session? All in favor?
Aye.
So
mayor
for
and me.
216 on the civics in schools, I have an amendment 0546, which totally takes out the commission. And that was done together with the originator of the bill and some other co-sponsors of the bill. So essentially, it's the same bill, except that whole section is taken out. The commission is gone, as is the effective date of that particular commission, so.
And Madam Chair, it looks like you also fixed that non-public versus
Yep.
private conversation
Yep,
that
we
occurred
did
with
that.
education DOE.
Yep. So do I have a vote on it?
Madam Chair, I move amendment number 546S on Senate Bill 216.
Second.
Any discussion? All those in favor?
Aye.
You?
Madam Chair, if I may.
Yes, you may.
So there's a second amendment. It's an amendment I've submitted to OLS. It didn't get back in time. It changes section 1B only in the bill. We could ignore the fact about the removing the commission because you already did that with the last amendment. So what this does is it just cleans up some of that language, and there was some language in there that was, for lack of a better phrase, ambiguous. I'd like to, how do you grade a student's appreciation for free speech and accepting other people's opinions? And so there were some things in there that I think would be subjective and problematic for teachers. So I cleaned up some of the language. So as you can see, in the new amendment, section A stays the same. I talk about the acquisition of skills such as the ability to analyze text and determine the reliability and biases of sources, as well as understanding the ways in which civic institutions operate and how individuals may be involved in civic life. And then C, I amended pretty heavily and removed D Appreciation for free speech and civil discourse, using historical references such as the Federalist and Anti-Federalist Papers, the major debates of the Constitutional Convention of 1787, congressional and public debates leading to the Civil War, and civil rights debates of the 50s and 60s. So again, the idea is to use historical references where debate occurred and debate was on both sides, so they can be an appreciation for how in a government setting and a political setting that you can have good discourse. I think that's cleaner than leaving it, and again, it's it doesn't limit it to those references, but again, I thought it was important to talk about how we talk about free speech and civil discourse. So it says such as, meaning that these are some of the ones you can use. If you want to use something else, that's fine too. But I'm just giving us some examples of historic debates that occurred, that there were both pro and con positions, and we can use it from a historical perspective, again, teaching history, which is what civics was about.
Okay, I have just received this morning, and the person who really is behind this bill has called me and wants to see the amendment before we do anything. So I promised him that I would send it to him because I said I haven't heard or seen the amendment yet. So in courtesy to Senator Khan, I will hold off on this one and we can do it next one, or we can do it on the floor.
Thank you,
Is
Bill.
that okay? Thank you very much. That takes care of 216. Now I see that Attorney Hewitt is here.
Do we want to
So let's get out of executive session.
second? Right.
All those in favor?
Aye.
Aye. Thank you very much. Now let's go back to 216,
219.
219. Okay.
All these twos.
It's Mr. Hewitt, please.
Press, just press, so that red.
That's a red light.
All right. It's the opposite in court, so always throws me off. Good morning, Madam Chair, members of the committee. I didn't know if I'd be able to testify again at this reconvention, but I thought it was worth a shot. Again, I'm Ian Hewitt, General Counsel at Cornerstone, appearing in support of Senator Murphy's bill, Senate Bill 219, as amended. And I'll just note that we and some others who are interested in this bill have been in touch with teachers who feel that they've been unfairly prioritized below highly paid administrators, but who I think may be perhaps understandably hesitant to testify against the interests of their current superiors. But I am certain that the committee will be hearing from those teachers via email, assuming it will not be hearing from any today. I wanted to again make myself available to answer any legal questions about this bill, but I thought I would just address the issue of collective bargaining agreements, because this issue came up after my testimony last week. And there's just, if we assume that if a district were to elect under this bill to raise the salaries of the lowest paid teachers in spite of the terms of a collective bargaining agreement, we'll just assume that that could be an actionable violation of the terms of the CBA. Even if we grant that, there's two legal responses there. So one thing that is uncontroversial, and I think the lawyers for the groups that oppose this bill would agree with me on this, is that when any employer offers a benefit in spite of the terms of a CBA, the union may always elect to waive the CBA terms with respect to that benefit. This came up recently last year with respect to an NLRB complaint against Starbucks. And so my first response is that in a scenario where under the statute created by this bill, a school district elects to raise the salaries of its lowest paid teachers, in that event, the union would waive the CBA terms as to the increase of those salaries. Because remember, in the scenario we're imagining, the district has elected to raise the salaries of the lowest paid teachers and keep all of its highly paid administrators. So the unions get then everything that they say they've wanted. They have every reason to give the waiver unless they want to publicly commit to the position that these low paid teachers just need to stay low paid. So the second response is that if we imagine that a district elects to raise the salaries of its lowest paid teachers and keep its high paid administrators, and the union says we are going to come out publicly as the teachers union and say these low paid teachers need to stay low paid, we will not give a waiver, we object. Even there, we wouldn't read the statute as requiring a CBA violation. We would just read it as saying that as a matter of prioritization, if you can afford to pay these highly paid administrators, what you need to do is cut your administrative expenses, and then you will have a surplus, which you can use when at the appropriate time you negotiate a new CBA that complies with the salary floor. So even in that latter scenario, this bill would still do exactly what Senator Murphy intends, which would be to say that if you have the surplus you can use to create a large administration, you may do that if you first spend it on students before you spend it on anything else. It would require the prioritization of direct student contact first, and so there would in practice be no way for this bill to require any actionable CBA violation. I'd be happy to answer any legal questions about the bill to the best of my ability.
Any questions from the Senator Lang?
All right, so again, I'm going to put on my school board hat, having negotiated 2 teacher contracts. So I guess my question revolves around things like the Sandown, I think it was the Sandown case, that requires when the public approves a CBA, that they have to show the 3 years, the length of the CBA agreement, how much the cost is for that CBA agreement. So in this case, we would, if I understand your argument right, if a school fell within this parameter, that cost metric would be off from previous CBA agreements, and the public had no notice that, oh, by approving this one extra administrator, we just cost us an extra $5 million in teacher salaries because we hired this assistant superintendent. So is it your understanding that if a district were to hire a second district a superintendent or a second assistant superintendent or an equity and diversity officer, there would have to be similar notice?
Well, I'm not familiar with the Sandown case, but as I understand your hypothetical, there's some kind of taxpayer standing here to challenge this expenditure by the school district. Is that roughly correct?
Right. So the Supreme Court's ruled that when you do a collective bargaining unit agreement, you have to show the cost to the taxpayer for all the years of the collective bargaining agreement. So this year it's going to go up by this much money. Next year it's going up by this much money. In the third year it's going up by this much money. In the case of a 3-year contract, that's required under Supreme Court law. So, or Supreme Court decision. So the question is, now we run into a situation where we would be hiring a superintendent at the school board level, which would negate all of the notice we've given the public.
Right. Well, if it's a matter of state statute, this would be a state statute, and so it would change state statutory law. If it's a matter of state common law can be overridden by a statute. If it's a matter of federal law, we've seen clearly under federal law that we can reference that waiver issue I referenced earlier. If it's taxpayer standing, which I think is what you're saying, Senator, then my response would be that the taxpayers have a choice to either hire these highly paid administrators or not hire them. And the taxpayers then have to choose between the options presented to them by the statute, but they still have a choice. If there is some kind of actionable violation that results from raising the salary floor, the option 2 I discussed is that what the statute would then require, if we just assume there's an actionable violation, is the district needs to cut its highly paid administration, and then it has a surplus that when it negotiates a new CBA, which complies with all of the conditions you're describing, then it now has extra money it can use to make sure that its new CBA complies with the salary floor. And in the interim, it's just saving money on administration. So that would still do, what Senator Murphy is imagining, which is require you can't spend this on anything until you spend it on direct student contact.
Thank you.
Any other questions from the members? Senator Prentice?
2 questions. One, Attorney Hewitt, thanks for coming back this morning. So was it your intention when we recessed this meeting last week that to bring back more speakers, that you were going to bring teachers with you who are not comfortable speaking? How you opened your testimony today is you had some people, teachers who maybe agreed with this, but were not comfortable speaking publicly. Is that, because I was on the impression we recessed because there were multiple speakers, more than one, that were going to come back.
I know that others have been in contact with teachers besides us, but we have connected with 2 teachers that I know of who had expressed interest in testifying on this bill, but were on a kind of February break during the previous hearing and expressed and indicated that they would perhaps be able to testify at a future date. I expect that some of the teachers, both whom we've connected with and who we haven't directly connected with, are hesitant because they would be testifying against the interest of their superiors. I hope that answers your question.
It does. Thank you. And the second is I'm still trying to understand why so first of all, I'm going to say that I am in favor of improving salaries for teachers and that direct classroom, how teachers interact and touch with students, the investment there. So don't get me wrong, but why, I'm trying to understand the purpose of targeting a specific number of school districts, telling them what they can and cannot actually pay. And then, as I brought up last week, the particular, if they have multiple superintendents at a certain rate of pay, then they can't have, say, a diversity professional. I feel that that's, so I'm still not, I am in favor of improving teacher pay, no doubt, but I can't seem to understand how this really gets us there statewide. It targets a certain group of people. Maybe this is just more of a commentary, but I'm just not there.
Yeah, well, thank you for that question.
Just to be honest.
Sure. I would say a 2-part answer to that question. So one, as far as dictating to localities what they can and can't do, of course, this would present them a choice because the goal is prioritization. And what I would say is that while we generally want to respect local choice, this is precisely the kind of area where there's a systemic problem that the legislature should address, because it's happening all over the state and the same thing is happening all over the state. And it seems to us that these school boards don't see the forest through the trees. All you see, if you're on a school board, perhaps, is your superintendent is coming to you saying, we need more money, we need more money. And it's only when the legislature steps back and looks at the whole state that we can see, wait a minute, we've increased per pupil spending 77% over 20 years, and none of that has ever increased average teacher pay at all, even though that's one of the main reasons we're trying to increase spending. So there needs to be some kind of systemic recalibration one way or another to address that problem. And the second answer that I would have to your question is, I would say, and I would ask this too of some of the teachers unions and other groups that testified against this bill. I think it's important to consider let's suppose, and I think this is quite easy to imagine, in 5 to 10 years we have twice as many of these highly paid diversity professionals. We have twice as many assistant superintendents, so maybe there's 20 districts that are would be affected by this bill, and still imagine that we have no significant increase in teacher pay. So, I'd want to ask the teachers unions, would you then now agree that we need to deprioritize these highly paid administrators and first increase teacher pay? And if not, it seems the taxpayers are sort of, held hostage to these offensively low teacher salaries that are never actually addressed until we have an administration of some undefined size.
May I follow up? Thank you, Senator Ward. I was never on a school board, but I was a city councilor, 12 years, and a mayor, and I always take, I'm concerned when we meddle in the business of local government, and I believe that local government knows best. We have to be careful. This is one of those places where it's potentially precedent setting. And I heard our own governor talk in his opening address in the State of the State about trusting the people on the ground that know the job. So I just wanted to make that clear. There's some precedent setting here, and I think we share the same goal in terms of how teachers are paid, but I'm not sure. I'm uncomfortable that this is the way to get into the weeds on it. I just want to be 100% honest. So I would certainly be happy to hear from any teachers, and if they felt that they needed to do so in a one-on-one setting. I have plenty of people who call me, and I imagine call other senators when they're not comfortable here, but they want to talk about their concerns, and that you would encourage them to do that. Does that sound fair?
Thank you, Senator. We'll certainly encourage those teachers to email the committee members, and I expect they will.
All right, and I'll talk to a few school boards, school administrations in my district. Okay, thank you.
Thank you, Senator.
Do you have any? Any? Okay. Thank you very much.
Thank you, Madam Chair.
Cool, thank you.
Anybody in the audience who wants to say anything on this bill? 219? Brian, you want to talk about it?
Well, we already commented on the bill at the original hearing.
Do you have anything new?
Well, I guess I would just, and maybe I can put some of this in writing to the committee, but there were a number of hypotheticals thrown out there with respect to the collective bargaining process. And so I thought I would just say, well, first of all, Brian Hawkins for the record, NEA New Hampshire. The salary floor piece, I'm still a little bit confused on how, if that is set, that would obviously set a minimum floor, but then theoretically that could also trigger an impact bargaining situation, which would also mean, what do you do when maybe the mid-level or the longest serving teacher is now below? There's a scale, and so the concern there is, what happens there. There's obviously, as was referred to before, the town meeting and funding process that Senator Lang referred to. And also teachers are not under the NLRB, they are under the PELRB, the state's Public Employee Labor Relations Board.
Okay.
So those were the only comments I wanted to add.
Okay. Thank you very much.
Thank you.
Anybody else? Mr. Fruit? Welcome.
Good morning, Madam Chair and members of the committee. My name is Jerry Frew, the Associate Executive Director of the New Hampshire School Administrators Association. I had not come this morning with prepared remarks, so I will make this very brief. But I do believe, in deference to what has been indicated by Senator Prentice and others, that these decisions are best made at the local level with locally elected officials who, with full transparency. They know what the salaries are. They make the choices of whether they're going to add to their administrative teams or not. They make the choices through the collective bargaining process of what they're going to set as their teacher wages and other benefits. I would submit that this piece of legislation speaks to one specific area of benefits and doesn't address other things like the other benefits that happen during the collective bargaining process. This addresses simply wages, and there are other advantages that are set in that locally developed, locally agreed to, locally supported practice. And so I just wanted to weigh in on that. And I would also submit that the figures that are set for salaries for assistant superintendents and superintendents in the bill language take the upper end of the salaries, and the state of New Hampshire publishes the salaries of the superintendents, the assistant superintendents, the business officials, all as a matter of public record. And those are accessible on the New Hampshire Education Department website. And I would submit that if one were to do the math, that they would find that the superintendent's salaries, probably are not, there are not very many in the $178,000 range. I think that most folks would find that they're well below that. And I would submit that superintendents work year-round, and I'll even go so far as to say 7 days a week, and especially this time of year. So thank you for your time. I appreciate the
very
opportunity
much.
this morning.
Anybody else? Senator Prentice, did you want to say
Oh,
something?
no, I was just,
Oh, I see, okay.
because Mr. Frew and I have a neighbor in common that
I
we've
see,
discovered
okay.
over the years, so.
Well, since there's nobody else, that concludes the hearing on 219. Next one is Senate Bill 2113, and Senator Waters will introduce it.
I'm Senator David Waters, District 4, to introduce Senate Bill 213. Simple bill, more complicated backstory. As you'll see in the bill, this addresses student privacy and social media accounts and our policies on those. and it adds the phrase, "This definition shall not apply to platforms used for demonstrating evidence in student career development." First, let me give a little bit of the background. Some looking around, I don't know if anybody in the current committee was here when we worked under Senator Reagan and Representative Kirk and others to address issues of student privacy using social data platforms. This arose from concerns about testing and other kinds of things that are available on platforms as to what kind of student information might be collected during that process by data aggregation. And then also it was a response to some really egregious cases of abuse that had occurred online by a teacher in 2 different districts. And so we really worked very, very hard, not only in the House, but then when the House bill came over in the Senate, to get a bill that we thought offered the appropriate protections. Fast forward a few years, and obviously with COVID and other things, the great expansion of use of online data platforms for the basic ways in which students get an education and also find employment. The particular issue arose last spring in some educator meetings about the use of LinkedIn. LinkedIn is a platform that is really essential for a lot of students who are moving towards employment or credentialing, particularly in the areas related to career and technical education. So at first, what we proposed was to accept just that platform. Then further discussions with the Career and Technical Education Advisory Council, and then a lot of discussion over the summer and the fall in the Department of Education, that recognizing this is a more broadly based problem that we're having. And you'll see the letter from Commissioner Adablu to Ms. Hawley laying out some of the ways you can see in this letter that career and technical education students really need to use these platforms if they're going to get the credentialing certification, which CTE education is all about and which it promises. So there was work during the fall by the attorneys in the Department of Education on this, and so I've decided to move forward the language here, which I thought would be comprehensive enough to cover other things. Had some more conversation with Commissioner Adablu last week, and he thinks that that they may want to bring an amendment in which clarifies some of the things that are in his letter here. So I will follow up with him, and I would hope that by the time you next meet, if there is a need to change this language, that we will have something from Commissioner Adablu. I do think that in a sense what we have here does most of the work. So I will stop there and see what questions that you might have.
Okay. Questions from the members? There are none.
Very good. Thank you very much.
Thank you.
And I will keep
Anybody
you-
else?
I will keep you posted.
Okay. Anybody else who has something to add to this, to 213? Seeing none, that closes the hearing on Senate Bill 213. Now, Senate Bill 135. I will.
The Vice Chair recognizes Senator Ward to introduce Senate Bill 135.
Thank you, Madam Vice Chair and members of the committee. I am Senator Ruth Ward from District 8. And I have the pleasure of introducing 135, Senate Bill 135. Let's see here now. Okay, so this bill allows the parties in an alternative dispute resolution procedure for special education services to mutually agree to continue conferring after the 30-day period. When parents and school districts are in conflict over the provision of special education, the law provides for alternative dispute resolution in the form of neutral conference and mediation. The implementation of the alternative dispute resolution processes fall within the purview of the Department of Education Office of Dispute Resolution and Constituent Complaints. The department's alternative dispute resolution processes are flexible, confidential, and informal processes in which an impartial third party assists parents and school districts to solve a conflict. The trained alternative dispute resolution officer's goal is to help the parties to explore the issues and ultimately, where possible, to resolve the issues. The goal throughout is to open up communication and reduce conflict between the parties. SB 135 would, excuse me, SB 135 would add in a provision that would allow for a continuance of the relevant process if mutually agreed on by the parties. This will provide more flexibility in scheduling sessions as the current 30-day limitation can hinder successful resolution. And the Department of Education will be in attendance to answer any questions that you may have. Thank you.
Thank you, Senator Ward. Any questions for Senator? Okay.
Good.
Thank you.
The Department of Education can answer any of those questions much better than I can.
The Vice Chair recognizes Stephen W.F. Berwick to speak to this bill.
Good morning, members of the committee. My name is Diana Fenton. I'm an attorney with the Department of Education, and it is my great pleasure to have with me today a member of our team, Stephen Berwick. I will let him introduce himself.
Good morning, Senator Ward. Thank you for your sponsorship. Thank you for the opportunity to speak today. I wrote some notes so that I wouldn't forget what I wanted to talk about. I'm the administrator of the Office of Dispute Resolution and Constituent Complaints for the Department of Education. Part of my role is administering the alternative dispute resolution processes for the Department of Education as well as State Board of Education. New Hampshire's alternative dispute resolution processes are flexible, confidential, and informal processes in which an impartial third party assists parents and school district to resolve a conflict. Alternative dispute resolution sessions can be done through mediation as part of a due process hearing, standalone mediation, a neutral conference, and a third-party discussion led by moderator. The trained alternative dispute resolution officer's goal is to help parties to explore issues and ultimately, where possible, to resolve disputes. Parties may bring an attorney with them to any of the alternative dispute resolution processes. Parents or guardians may also bring an advocate, supported decision maker, or anyone else they feel will be a support to them if they choose to do so. The desired outcome throughout is to open up communication, reduce conflict between parties, and ultimately for the parties to resolve the problem and put their agreement into writing. The change in language to SB 135 to include the opportunity for parties to mutually agree to continue a schedule would be beneficial to the parties. There are times when one day of mediation, for example, does not afford the parties enough time to resolve the dispute. For example, a second day of mediation beyond the established 30-day window may be all that is necessary to resolve the dispute. Additionally, parties are often accompanied by counsel who, for whatever reason, previous case or court commitments, etc., aren't available for dates previously agreed to by the parties. Other times, a reschedule beyond the statutory 30-day timeframe may be required due to a necessary expert or school official on leave or other required commitments, or a parent with work or family constraints. Sometimes a follow-up session or sessions is necessary to hammer out details or on especially difficult cases involving IEP, placement, compensatory services. Those are largely what end up coming to mediation. Alternative dispute. There are instances where parties are in agreement on a placement of program, but before final signatures can be applied to the final agreement, they are waiting on expert reports or openings to approve non-public school placement that may be more time than 30 days allows. To change, the change to RSA 186C23 would remedy those challenges to the limitations of a 30-day timeframe. Thank you very much.
So in short, the bill before you is pretty simple. It just adds in a provision that allows for a continuance, and this is a very common practice. It was a common practice in court. It's a common practice in any of these hearings. But the reason I wanted to bring Stephen before you today is I think it's a rare opportunity that the department gets to talk about the amazing processes, not really sure, that it offers to the citizens of New Hampshire. And it's a program that Stephen has really built from the ground up, and I always like to take the opportunity to applaud his work, because he really has built this system on his own, and it really is quite something. And the bill before you only strengthens that process that we provide to school districts and to parents and families. It makes it easier. And I think informally, and I always hate to say informally when I'm on camera, but I think informally this is a practice we've been doing, but we need to have the authorization to do that, and that's really what this bill accomplishes. But if you have any questions as it pertains to our process or the other services we provide, this is the gentleman who can answer those questions way better than I can. So we're happy to answer any questions you may have.
Thank you, Diana and Stephen, for being here testifying. Any questions from the,
Okay.
Thank you. I'm just curious, how often do we have these situations?
Let's see. I would say, for example, due process hearings. I've been around since 1984, and
1904?
1984. Sometimes I feel like 1904.
You look great.
Thank you. So, for example, special education impartial due process hearings, we get about 40 requests a year. And of those, maybe 15 to 18 get mediated. And if, for example, 30 days were to be extended, sometimes what happens is things that settle really would have mediated, or things that were withdrawn may have mediated. There has been, since the last 10 years, the federal government has been very keen on parties resolving disputes outside of hearings. And so our push has been for mediated agreements, first and foremost, resolution sessions locally, settlements. And so, yeah, to answer your question, there, about half of the requested hearings end up going through settlement, mediated agreements.
Okay, thank
But
you.
I think it's important to recognize by the time an issue reaches the Department of Education, it's pretty heightened. And I think that's why our process becomes so critical. We have to provide a good service to the people that we serve because the issues are so important. And again, by the time it reaches the department level, I think it's important to recognize that both sides are heightened. And I just think as an attorney who's certainly experienced that myself, it adds another layer to the complexity of it and the importance of the process that the department provides. And so I think in terms of this bill, which is before the committee, this language is not complex. This is not a complex bill. This committee has certainly seen more complex issues, but it will mean a lot to the parties. The ability to continue it out, it just gives a little bit more breathing room and freedom. And that's why this bill is important. And we again thank Senator Ward for her sponsorship of it. And this is why we wanted it to bring it forward, because it just helps parties who are in a really tough spot already.
Thank you. Any other questions from the committee? No? Okay. Thank you very
Thank you
much.
very
Is there anybody else in the audience that would like to speak to this, to the Senate Bill 135? Okay, hearing none. This ends.
I have to wait until 9:45.
9:45. The Vice Chair recognizes Senator Ward to introduce Senate Bill 136.
Quick, everyone. Let's go.
And look, we went out with 3 and we came back with Megan Tuttle. So yeah, we had. Okay, here, that's fair.
Thank you, Madam Vice Chair and the members of the committee. I'm Senator Ruth Ward, Senate District 8, and I'm here to introduce Senate Bill 136. It prohibits the hiring of service of a person by a school administration unit, school district, charter public school, or non-public school who is listed on the Department of Education's list of revoked or suspended educators. SB 136 would continue the Departments of Education child safety protocols by amending RSA 189:13-A to insert a provision that would prohibit an SU, school district, charter public school, or non-public school from being able to employ an individual who is on the Department of Education's list of revoked and suspended educators. That same prohibition would be equally applicable to individuals who wish to volunteer within a school district. The department is here again to answer questions relating to this particular bill. Thank you.
Thank you, Senator Ward. Any questions from the committee? Hearing none. The Vice Chair, there's nobody here to speak on it, but we do have, you do want to? Okay. We do have somebody that's in favor of it, Representative Alvin C. of Merrimack. He's in favor of it, but he does not want to speak, so.
I have a question for you.
Sure.
So, however this
We can
rolls out.
come up
Yes.
Absolutely. Good morning, members of the committee. This is fun. Rarely is there a time where the Department of Education gets to sit with the union and testify together. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. I will certainly let Megan Tuttle introduce herself, but I want to take a moment to say sometimes our agencies are naturally at odds. It happens, but I want to just take a moment to say that I appreciate the union's cooperation on any of the child safety initiatives the department has undertaken. And we've had years now of the department working on child safety initiatives, and the union has always come to the table, always worked with us. And I will just tell you anecdotally, I called Megan on Friday morning at 8:30 to put this bill on her radar. And that was probably not the most courteous thing I could have done on a Friday morning before a 3-day weekend. And by the end of the day, Megan had a draft amendment to me for my review that I could certainly live with and that I think the committee has in front of them and that we'll discuss momentarily. And I want to genuinely thank Megan and the union for their cooperation on this and other initiatives. And I just think it's important for the public to recognize that there are a lot of issues where we disagree, but when it comes to child safety, this is the cooperation you see. And I wanted the committee to see that as well. That being said, long-winded me, I'll turn it over to Megan.
Thank you. So for the record, Megan Tuttle, President for NEA New Hampshire. I did send the amendment that Diana Fenton was talking about to Senator Ward last night. I do have it here. If you don't have it, I wasn't sure if it got. Okay, I have copies for everyone, so let me pass those out.
Okay.
Thank you.
We have extra.
So, yes, Diana did call Friday morning. We had worked on this. The changes that we're proposing, we don't think really do anything in terms of the meat or the intent of the bill. It just made it a little bit more specific to make sure that if your name was on the revoked or the suspended list, that you still had the rights as a parent to go into the school. So we're not saying that if your name is, you get your certifications or your license revoked, that you should be able to be hired in a public school to teach. That's not what we're saying. The intent of the bill is still the same. It just clarifies it so that, you know, for example, if my license was revoked as a parent of 3 children, I could still go to school events to see those events, graduation, things like that. Probably not chaperone a week-long DC trip. That's not what we're saying. But to still go in and have those rights afforded as a parent. We also wanted to just kind of clarify on the suspension list. We do know of some instances where it has not been updated as timely as it should be. So there were still names on the suspension list that they were no longer suspended. And that could, you know, hinder getting a job somewhere. Even with language written, the wording that we put in would just make it in our minds a little more clear that once your name is, you know, once your suspension is up, you're off the list and that's it. So that you could get employment moving forward. I think that explains it, but I'll take any questions as well.
Any questions from the committee? Senator Prentice?
Thank you, Senator Gendro. And so my question is for Diana Fenton, Department of Education. They DOE, it's so insensitive, sorry about that. So I'm looking at the amended version in front of us, but it's also in the original version. I just want to clarify. Section 1, I think it's line 3 under C, a school administrative unit, school district, chartered, public school, or non-public school. So non-public, who is that defined as? And I'll have a follow-up to this too, just. So would it be religious? Right. Could it be religious schools?
Let me do this. I like to look at it in context. I apologize. Usually I have my law book with me.
I'll give you the context. Can I give the context? Go ahead, you do yours.
You can give me your context. I like to look at it in the statutory scheme. I will get back to you on that, but I want to just make sure that looking at it in totality, I give you the right answer, because I think that typically there's non-publics, if they choose to follow 18913A, they have to do so in entirety, but they're not obligated to. So this is, let me look at the statute. You and I can look at it in totality and get you that
What I
answer.
probably should have done was
That's okay.
flipped how I approach this. I'm just trying to make sure that this covers, that the DOE, you know, well, maybe it is a question. Does the DOE have authority in this area over non-public schools?
So if memory serves, and again, I apologize, I left my law book in my car this morning.
It's rare. I never see you with
It is, I know, I feel a little like out of.
I don't know what to do.
I usually have it with me. It's one of my defining characteristics. If memory serves, the statute provides that non-publics can choose to follow the provision of 18913A. And if they do so, they have to follow it completely. They can't cafeteria
You can
style.
choose. Okay.
Correct. And so we have worked with, for example, Brewster Academy. We've worked with Brewster Academy, and Brewster Academy has decided to, and I'm not here to speak for Brewster, but they decided to follow the provisions of 18913A, and they had to work with the Department of Safety as to how they could do that, because they are a non-governmental entity, and as this committee is well aware from working with state police, and Senator Prentice, you probably know this better than I, but non-governmental entities are not allowed to get the FBI background check. And so Brewster Academy, in deciding to follow the provisions of 18913A, had to find an exception, and they did it through the Adam Walsh Act, by which they could obtain the federal background check. And that might have changed. I'm not familiar enough with Brewster's policies, but that is what we've experienced with non-publics, is that if they follow those provisions, they have to take the entire statute and do that.
You'll follow.
I will absolutely follow up with you. Yeah, no, I appreciate that question.
Here, you know, it's great to see you both together. And, oh, I thought it turned out. It's great to see you both together. And if the intent here is to, you know, again, you know, protection for the children, then we need, and non-public is mentioned in here. I just want to make sure you have the jurisdiction. That's all.
Yeah, no, I appreciate that question. I will certainly follow up. And I think just in kind of a broader context, recognizing the importance of the revoked and suspended educator list, the department doesn't take that lightly, and I know the union doesn't take it lightly. There are some really serious offenses on that list, but I think when we look at this particular area of interactions with children, not all those interactions are criminal. And so this idea, well, I'll just Google this applicant and this information will pop up, doesn't always work. And so the story that I want to share with the committee, and I will be brief, we had an educator, I think Megan is aware of this story. We had an educator in a district who wrote a love song to a 13-year-old child in his class. Wrote a love song, sent the love song to the child. I have the lyrics of the love song and sent a clip of him playing it. It is not illegal to write a love song to a 13-year-old child. If you want to do that, you may certainly do that. The superintendent took all necessary steps to terminate his employment. Superintendent acted appropriately, swiftly, everything within her power. She did it right. But without the department's action of taking action on his license to teach, I assure you that person would go to another district. And that is was the flaw in the system that was employment based. He would go to another district, and that is where that term pass the trash came from. Lawyers are a piece of work, but the pass the trash comes from education. Nobody likes lawyers, myself included, and I'm married to one. But pass the trash is exclusive to teachers, and it is because of that. It's from employment to employment. And so that gentleman, I assure you, is on our revoked and suspended educator list. But you can Google him and you won't find that in any newspaper article. It's not a crime. But we can all agree that we don't want that working with children. And that's why this list becomes really important. And the department's past practice has been to say in its revocation agreements, which are reviewed by the union and signed by the union and signed by the individual and then subsequently signed by the department as part of our due process provisions, those agreements will put in a provision to say, this individual, you shall not work in an uncertified capacity or volunteer at a school. The onus has been on the person. But we want to share that. We want the school districts to take some responsibility too of looking at the list, recognizing the importance of that. I do want to address Jerry Fru's concern that we mentioned, that if somehow someone was hired who was on the list, that it was just an oversight, and those things happen, that there would be no penalty to that superintendent or HR director. This is not in any way a gotcha. This is not a gotcha provision by the Department of Education. We're not looking for people to take action on. We just want to strengthen that child safety piece, just, one more little crank. And I'm just, again, I thank the union for their support in it, and we are in complete agreement with the amendment, and we're happy to address the Superintendent's Association as well. So it's not in no way, shape, or form do we want this to be viewed as a gotcha.
I got a question. So those that are on this list, is it a forever list? Or is there a way they can redeem themselves?
Sure. So if you look at our code of conduct, we have 4 forms of action, 3 forms of discipline. The 4th form is we close out the case, right? It's unfounded or we can't prove it. And what we'll do if we close out a case, which we do quite often, we'll send a letter. The department's not taking any action. There's nothing here. We'll send that letter for a variety of reasons. As I mentioned before, we can't prove it. There's not enough facts to prove it. Or we decide it's an employment issue. Right? It doesn't rise to the level of credentialing. And we close out the case and we move on. The 3 forms of discipline are a letter of reprimand, which is private between the Department of Education and the individual. That letter goes into their credentialing file, which we maintain. They receive a copy of it, but it doesn't affect the validity of their credential. And we have found that to be a really useful tool. I had one educator that we put a reprimand on, and she actually wrote me a thank you card and was like, thank you so much, which I was like, you're welcome. I think of it as the rumble strip on the highway, right? You drift out of your lane a little bit, maybe you could be a little bit more professional in your action. And it's a great opportunity. We all need those rumble strip on the highway moments, myself included, to just tap you back in your lane a little bit. And so those have been a really effective tool in that way. And it doesn't affect the validity of the license, so that person can keep being employed, seek other employment, what have you. Then we have a suspension and a revocation. I'm going to talk about the revocation first. Revocations are for when an educator has had an inappropriate relationship with a child, period. The department takes very strong action on those. We do not think that a class or a course will correct that action. You know, the case we always refer to that the union has asked me to stop referring to it, and someday I will, Megan, is the case out of Concord with Howie Lawan, right? Having a relationship with two victims that we know of, having sexual relationships with those girls. The department's position is you're not going to fix that with a class. He is revoked. He will never be able to get a teaching license in New Hampshire. And so that is, we reserve, if you will, reserve that kind of sanction for those egregious cases. When you look at the suspensions, we both agree that there are some activities that a person needs a break from the classroom, but we can work with this. We can work with this individual, have them take some classes and courses, and support them and get them back in the classroom. And so we have worked successfully with the union to come to terms on what length of suspension is appropriate. And that can really range. But we've had I'm going to say, successful working relationship to come to terms on that. So to answer your question more precisely, revoked educators are always going to be on that list. They're not coming off that list. But if you are suspended and you serve the terms of your suspension, we then remove you from the list. I will go one step further to say that the list is public information. It's on our website, and the department, every time we add to that list or take a name off that list, anytime we change it, we send it out to the districts again. And so we do that on a kind of a continuing basis so that our communication with the districts is clear and transparent, and so that people have the updated list.
Thank you.
I have a question. So this person who wrote the love letter
Yes.
is on the list, cannot work as an educator anymore, right?
That is correct.
Okay. So if this person goes to another state, several states removed, will they, in that term, check with the original place of work and they find the information?
That is a great question, and I thank you for that question. There is a group called NASDAQ, and it sounds like the stock market piece, but it's not. It's the National Association of State Directors and Teacher Education Certification, and I'm not sure if that's entirely correct, but I will get you that acronym. I was blown away by this group when I first started at the Department of Education. I thought forever we were talking about the stock market, and then quickly I learned that we weren't. It is a private group. It is not government. It is a private group that recognized we have educators moving from state to state. We have a problem. You have to pay a membership fee to be a part of this. When we license someone to teach, we, the Department of Education, we will run their name through NASDAQ. In fact, a bill came before this committee last year that allowed the department to use their social security number. So we will actively run names through NASDAQ. Each state, their individual Department of Education, they will enter the name of educators who have been revoked or suspended into NASDAQ. So to answer your question, if the songwriter goes to Vermont, Vermont has membership in NASDAQ, and they will look in NASDAQ and see that his license has been affected in New Hampshire. Correct. Now, there is no requirement that any state has to be a member of NASDAQ, and there's no oversight as to who enters or when they enter or what they enter. But it is a longstanding organization, and it is a safety measure, and the New Hampshire Department of Ed is a member of it. And the idea being that other states will recognize and reciprocate the action that we've taken. And we have gotten calls from other states saying, this person is trying to get a license. What is the factual basis upon which you took their license? So we have those conversations quite frequently. I can't say daily, I can't say weekly, but yes, we have had them.
Okay, thank you.
Go ahead. You got a question? Okay.
Oh, I thought you were- isn't NASDAQ, I mean, NASDAQ sounds like, the stock exchange,
It
but
does.
is it an interstate compact? Because you're talking about what is essentially like a coordinated database, and just for clarity, for everyone's like relief, I mean, a coordinated database is like completely, they're there for, public protection. But you have to have membership to an organization like that to be able to access it. So
Yes.
just for the clarity for the record, it's not like I could just go online, find this group and look. So, and the
No,
ho-
no,
and the
not at
home
all.
state, follow up. Because home state controls the license even if,
Correct.
okay, perfect, thanks. Just like driving a car, your car license.
Yes, it's similar to that process. And I'm very familiar with the reciprocity that Department of Motor Vehicles takes action on my license. Massachusetts will find that, they'll revoke, right, they'll revoke my license as well. I think that it's not quite as clear, perhaps, just because states will take action on an educator's license for a variety of reasons. And some of those might include employment reasons that we would not take action on. And so that is perhaps an area that could be rectified. But your idea that, yes, this is an interstate idea compact, but it is the state of New Hampshire Department of Education in New Hampshire that holds the license. That you're absolutely correct. Thank you.
Any other questions, follow-up, comments? Okay, thank you.
Thank you very much. And when the union and the department are at odds, we can all think back to this moment and replay the tape. We have it. That's right, it's on video. That's right, exactly. Thank you very much. Thank you.
Thank you.
Thank you.
I don't have anybody else on the list, but is there anybody else in the audience that would like to speak? Okay. This concludes the discussion on SB 136. We've got to do another one, right?
Yep.
Do we,
Next one is
10, so we're okay on that one.
266.
266.
Okay.
Okay. So the vice chair recognizes Senator Ward to introduce Senate Bill 266.
Current members of the committee, I'm Ruth Ward, Senator from District 8, and I'm here to introduce Senate Bill 266. So this bill modifies and recodifies education laws on the administration of and criteria for the statewide education improvement and assessment program. The criteria for an adequate education, accountability, and education reporting. This bill is being introduced on behalf of the New Hampshire Department of Education to make technical corrections. It addresses two areas of law: state assessments. This bill clarifies the statewide student assessment program, including the state's obligation to administer an assessment in grades 3 through 8 and 11. State accountability for an adequate education. This bill clarifies the criteria for an adequate education. This bill removes language duplicative or contradictory to the federal Every Student Succeeds Act. This bill combines two areas of legislation, which is confusing in its current format when read individually. This bill moves laws to a new section that are currently housed in adequate education, but they should be in their own section of law. And I know we have a very competent person behind here.
Does anybody have any questions for Senator Ward?
If they do, I can't answer them.
Thank you. We have Nate Green, who would like to speak in support. Okay. Thank you.
Good morning. For the record, I'm Caitlin Davis. I am Director at the Department of Education. We approached Senator Ward about introducing this bill on behalf of the Department of Education this summer, relative to some work that we're doing at the department. As far as the history of some of this language and the reasoning behind some of this bill and the need for it, the Department of Education in 2018 began working on the federally mandated Every Student Succeeds Act process and state plan. And during that time, language from the federal Every Student Succeeds Act state plan was included in the state requirement for an adequate education under RSA 193E and H, the performance-based accountability section of law. At that time, we were in the process of writing our state plan, and we had not actually implemented the ESSA plan for the first time. And so some technical corrections and mistakes were made. So a large part of this bill is clarifying language that was put into the bill at the time that either is duplicative, so we didn't feel like it needed to be listed in the state law because it's listed in the federal law, or has changed, or the incorrect sections of law were originally identified incorrectly, and now we're updating that. And then we also removed some information that was left from the No Child Left Behind law, and that was in 2018, but not all of that was appropriately identified and removed. In 2020, the state law for defining what school districts were required to do for reporting for inadequate education changed. Prior to 2020, school districts were allowed to prove that they were providing an adequate education through either the input-based accountability system or performance-based accountability system. In 2020, the law changed into required school districts to do both. However, those sections of law are separate, and so if you read one or the other, it's very confusing without reading them together, which is why the department would like to move them into the same section, so all of that can be read together. In 2022, the Department of Education was finally able to hire, through the state budgeting process, a position to oversee the work of these sections of law. And in that process, we began reviewing the law and trying to put together a plan to implement the law, and identified other technical corrections in areas that need to be changed as a result of the work of that position. A lot of that is requiring the Department of clarifying the department's requirements and responsibilities around assessments, removing the duplicative ESSA language or language that is in the state plan that was in the previous state plan that has been updated, adding definitions that were missing or not within the definition section of law. If you read the current law, it's very all over the place. And then there are several sections that are in this law currently that we would like to continue to exist, to have them in law, but we didn't feel that they belonged in this specific section of law. Predominantly the language around the unique identifier system, which is a unique pupil identifier system that we use for a variety of different state and federal reporting requirements. It's a very important section and enables the Department of Education to do do data work that is, or to validate data work. We need that, but it just does not belong in this section of law. The Holocaust Education Commission, which could be in its own section. The Legislative Oversight Committee, for example, is largely about accountability, but actually right now falls within the assessment section of the law. So we suggest removing that and moving that to the accountability section of the law. So there's a lot of examples of that. We do realize that with the format, with the total repeal and replace of these sections of law, it can be a little confusing. So we are here to kind of go through this as the committee feels and ask any technical corrections, ask about any kind of the definitions or whatnot that we wrote, and Nate is going to be able to do most of that work. So,
Any questions from the committee?
thank you. So what you're saying is you have cleaned this thing up and put it in certain sections so it makes more sense.
Correct,
No major changes or deletions or anything.
correct.
Okay, thank you.
Any other questions before Nate speaks? Okay, Nate?
Sure. I'm not sure if I have anything more to add if the committee doesn't have any additional questions. The only thing I would just say is that for the most part, the corrections that we've introduced into this bill here represent our current practice. So what we're proposing here is not a change from what the department is currently doing. It just brings the statute into current line with what we're required to do federally already and what our current practice at the department is. It really is a cleanup bill.
Any other questions, comments? Senator Prentice?
Thank you, Senator Gendro. I appreciate you, Caitlin and Nate, both being here today. And as I understand this, just for the record, you have spent time taking the federal law, the state law, the current practices, and aligning everything as it is today, providing clarity across the board for those that are working within not just your department, but are overseen by your department. So this is, it's really a major step forward in cleaning this up.
Yes, yeah, I would say a major step forward and a step that's needed,
Yeah.
both for our staff who are implementing the law, the federal and state law, as well as districts, teachers and administrators in the field that are going to this to make sure that they're putting in practices and policies and procedures in place in their districts to make sure that they're aligning with the law. And this helps to clear up some confusion that, we've been trying to clear up with the field over the last few years, but still exists within the statute.
Great. Thank you very much for your work. Right.
Thank you. Anyone else? Hearing none, I guess we've got, nobody else has signed up. Would you like to speak?
Thank you.
Thank you.
I apologize for my tardiness in signing the sheet. Thank the committee's indulgence for my actions. Just very briefly, I would like to acknowledge specifically Caitlin and Nate. Oh, I'm sorry, Jerry Frew with the New Hampshire School Administrators Association. I would like to specifically acknowledge the outreach efforts of Caitlin and Nate in trying to work to create something that folks in the field can understand and comply with. They held meetings with several members of our association to gather information and offer clarity and answer any questions. And as Attorney Fenton mentioned earlier in the day, another collaborative effort between certain members of the department and the field to make things a little bit better. So just wanted to go on record as citing our appreciation for that work.
Thank you. Anybody else have questions, comments, or, okay. Thank you. Well, hearing none, this will close the hearing on SB 266.
All those in favor?
Aye.
You want to start with this last one?
Sure.
You have a motion?
Make a motion?
All those in favor? What was the motion?
OTP.
Yeah, OTP. That's what I thought, but I knew that.
Second Senator Gendro's motion.
Okay. All those in favor?
Aye.
You want to put it on consent?
Aye.
Second? All those in favor for consent?
Aye.
That's 5-0. Who wants to take it out? You want to take it out?
I'll take it out.
Jandra will take it out. Okay. Okay, what about 136? That's the no hiring of people who are put on a list.
Make a motion, OTP.
Second?
All those in, well,
Well, we've got the motion
yeah,
and it's been seconded. So now we can adopt the amendment. Is this considered a committee amendment?
I believe so, because I don't see that it's essentially replaces the original with the addition. So let's look at the amendment, which I don't have a number for because it has the bill number. Yeah, but it's the bill number, 915. So this would be a committee amendments. All those in favor? I'm looking at this one. Do you have it?
Pass them out. Hold on just technically for a second. Let's,
Yes, I do.
Yeah.
Okay, yeah, thank you.
It looks, some of the language is exactly as the bill,
Yes.
and then with the addition. So, okay. So let's look at the committee amendment. Those in favor? And who, do we have an OTP on it?
I move OTP.
Okay, and all those in favor?
aye.
So this will be a committee amendment to the original bill. So we go back to the original bill.
You bet.
All those in favor of the 26136?
Aye.
You want to put that on consent? The what?
Move consent.
Okay. All those in favor? Who wants to take it out?
I will.
Prentice takes it out.
Madam Chair, I'd like to make a motion to ITL on SB 219.
Seconded.
Discussion?
Madam Chair, if I may?
You
So,
may.
this one thing, this bill, while I kind of agree with the ITL recommendation, the one thing that did come out of this conversation was the conversation about administration versus teachers, right? And the fact that, you know, and I'm going to push this over into the conversation about general business, right? We fight all the time about the fact that CEOs make way more money than the workers in the field, right? And this bill kind of aligns with that conversation of the fact that in business we complain about how much money the CEO works and yet he pays lower workers nothing. And this is the same kind of conversation here in our school system. The fact that we are paying our administrators what some would say is exorbitant fees or wages. At the same time, our teachers who have direct contact with our students and our children in New Hampshire are not paid as much. And that conversation needs to be had and focused on and where we're putting our, you know, there's that conversation about where you put your focus, where your thoughts is where you go. And right now we seem to focus on administration and paying them really well to the detriment of our teachers. And it needs to be looked at. It needs to be assessed. And I don't know, you know, I think this is a collective bargaining nightmare, this bill. But I still think that conversation should happen.
Senator Ward? Yeah?
Please.
So Senator Lang, I agree with you. And when you were off busy, you know, introducing a bill, I talked about just those concerns that I do think it's a very worthy conversation to make sure that we're always moving the mark for teachers. They are the direct contact with the students. I agree on all of that, but I don't think that this is the vehicle to do it in. So I'm not opposed to having a conversation about how to, you know, better take care of the teachers on the front line. I think I heard somewhere that, you know, teachers should be paid like doctors. I mean, they just have these incredible jobs. But this that gets into local business dictates what local school boards will do, which is targeted at 8 school districts, et cetera, I didn't feel was the way to get at it. So I think we agree on what needs to be done. This is just not the vehicle to do it. I think I've heard some of that from you too, but I won't put words in your mouth.
So just comment, the interesting part is the doctors are paid more than the practice administrators. Right? And so, so I don't necessarily disagree, but just understand that not in that example, like our doctors are paid hell of a lot more than our practice administrators, people who run the practice. And yet in school districts, it's completely inverted.
I agree with what I have heard. I think this bill is not the vehicle to accomplish this. I would say we need a bill to address that particular part that needs to be much more focused. There are too many other things in here that is not really conducive to a good decision. So I have a motion of ITL.
Second.
All those in favor?
Aye.
All right, okay, all those in favor, ITL? That was 5-0. You want to put that on consent?
Madam Chair, move consent.
We have a second, by Senator Fenton. All those in favor of consent?
Aye.
That's 5-0. Who wants to take it out? Okay. Uh, 135? The conflict resolution. I'm going beyond the 30 days.
Which bill we on, Madam Chair?
130.
Oh, that you were not here.
Yeah,
No.
motion,
30 days sometimes is not adequate, and there should be a way of extending that. Do I have a
so
motion?
motion, OTP on Senate Bill 135.
Second.
All those in favor?
Aye.
Consent?
Second.
All those in favor of consent?
Aye.
Take it.
And Jandra wants
You're
to
so
take it out.
fast. I'm still trying to catch up. With-
Are you getting all of that, Pete? Good. Don't have any. Okay, what about 213? That's the social media platform use.
We just got that amendment today, right? Or
Not,
letter?
not on this one.
No, it's just a letter.
It doesn't have an FN on it, so we don't have, if you're not ready to vote on it, we can just wait until the next time.
213.
Yeah.
Mm-hmm.
Was there an amendment or?
No.
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 who sent the letter?
Yeah, it's a
From
letter.
DOE about
Yeah.
this.
I don't know. I would like to wait on it.
So, so the essence of this bill was if social media was not actually social media outside, putting it outside the career development of putting it outside the career development, outside the definition of social media account. So like LinkedIn, things like that. And the issue was that they were messaging on LinkedIn. If I understand the bill's intent correctly.
Then they also talk about the second paragraph. Each type of school district state on privacy governance plans should specifically provide for CTE students access to these critical tools and or provide an opt-in process permitting CTE students to access these platforms with informed parental consent.
The actual bill though doesn't say that, with parental consent, does it?
No. We just have that part. This definition shall not apply to platforms used for demonstrating evidence in student career development. Do you want to mull it over?
I'd like to.
Okay. We'll pass on this one. Okay, what about 216? No, we're gonna wait on 216 because I told Senator Khan that I would inform him of what we were doing. FN. Let's do 214. That's an FN. FN. FNs. How much time do I have for FNs? Oh, okay, so. Okay, let's just take these. Okay, let's do 214, that's establishing a Department of Early Childhood Education. And
I'm gonna make a motion to ITL.
I'll second.
have an ITL and a second discussion.
After you,
Okay,
ladies
no,
first.
I'm just curious. So let's just have some discussion. What's Senators Gendro and Lang, you could share with me where you're coming from in your ITL.
That's a good question. I'm not so sure we should go this route. I mean, there's a lot of reasons, but I just don't think we should go down this road.
Okay,
I'll give a little.
thank you.
So for me, the issue is twofold. Number one is creation of a new department that I think belongs under the Department of Education if we were to do this at all, and not create another high-level position at the, so to speak, cabinet level, another commissioner. As education from preschool all the way to K-12, through 12 should be uniform and be with a plan, and not have a plan for before kindergarten that changes once you hit kindergarten. So I'm concerned about the fact that it's outside the Department of Education. That would create new dynamics that we hope that the agency would work with the Board of Education, but we don't know that they will because the statute doesn't do that. The other thing was that part I brought up about we get federal funds, and there's been no clear answer. I know that, again, putting on my school board hat, when we were looking at full day kindergarten conversation, if in my particular school district, we implemented full day kindergarten, we would have lost federal funds because it went from what we would call K plus, which we had a half a day that was federally funded for kids that were not up to par, so to speak, or that were not on grade level. We would have lost all that funding. And no one's been able to answer the question other than saying maybe we would lose federal funds. And so I'm concerned significantly about establishing a pilot program that would possibly lose Head Start funds or pre-kindergarten funds in our statute. Until we can find definitive answers, I don't think that this is a great answer.
Senator Prentice?
Thank you very much, Chair Ward. And so, just as practice, so that especially you don't feel like I'm targeting you, like explain this to me. When I make an ITL or even some of the, OTPA or OTP or OTPA, I usually make a statement as to why I'm doing it. So that's why I'm just asking, because I want to understand where you're coming from. That is just clearly a respectful, practice of mine. And along those lines, So, Senator Lang, in terms of possible versus definite, in terms of, the federal funds, whether, I think I remember you talking about whether they will supplant. Was there a conversation about? Yeah. Do we need to get a definite answer on that? Because you use the word possible versus definite. Do we want to be sure, in respect to the sponsor, that we have exhausted all efforts before this should stop.
If I may, Madam Chair.
Sure.
So again, in aggregate for the whole thing, again, when I take the first argument that I had, which I don't agree that it belongs outside Department of Education, because I think education of a child should be looked at from beginning to end and not have a separate section that is governed by somebody else, as that goes. And then I look at the supplant of federal guidelines. And lastly, again, I'll go into this discussion that was brought up about the fade effect of some of these programs. The fact that full-time programs through the Anchorage and the Philadelphia studies have shown that after third grade, you can't tell the difference between a student that's been in a full-day kindergarten and a half-day kindergarten. That the academic acumen that is initially ahead falls to equal in those two longitudinal studies that were done. So again, I don't see the benefit in this bill moving forward right now. I think for all three reasons.
My problem with this bill is that it establishes a new bureaucracy with its own commissioner. The commission has the authorization to develop all kinds of departments within it. And also in the beginning of this bill, it talks about that New Hampshire is one of 6 or 7 states that doesn't have an early education program. 6 or 7 depends on which copy of the bill you read. One of them is referring to 6, the other one is referring to 7. The thing is that New Hampshire doesn't have a state-sponsored early education program. It does, however, have lots of private educational programs for preschool children. And I have looked up many of them, and they have certified teachers, they have an accepted curriculum, and they are doing all kinds of things, which is part of what we are looking at this new committee to do, this new commission to do. So I really don't feel that it is appropriate at this point. It costs a lot of money. We already have good programs that we can utilize, and it just establishes another group that has nothing to do with the Department of Education. And I do think that any educational programs should be part of the Department of Education. That's my take on it.
I'll add my 2 cents if I may.
Sure, absolutely.
No, I agree with you. We have some great programs out there, and as a father of a 4-year-old and a 2-year-old whose children are in these programs, they are massively expensive, and they're hard to get into. My son was on a 10-month wait list to get into one of these programs. So these are problems that working parents are facing, single parents, and low-income parents are facing. And I think the intent of this bill would really open up a lot of opportunities for that lower income constituent that needs that help finding high quality early education for their child. New Hampshire is really, really behind the 8 ball on early childhood education, and other states have such good programs, whereas New Hampshire, we're missing that mark, especially when it comes to attracting employees. I think the bedrock of attracting employees here are a good education, and accessible and affordable childcare options. And I think this bill would really be a conduit to get to that. Thank you.
Any further discussion? Okay, so I have a motion of ITL. So how do you vote?
Aye.
Aye.
Aye?
No.
No. Prentice, no. So it's 3-2. Okay. Do you want me to take it out?
Sure.
Okay, that's 214. That's one of the FN bills.
So we don't want that on consent then?
No, no, you can't. It has to be 5-0 for consent. I have 153. It's another FN bill. Senator Waters.
Madam Chair, if I may.
Yes,
So again, there's the conversation, I had a conversation with Senator Waters about, another bill, my Senate Bill 104, which is the online gaming and two-year scholarship fund, that, and expanding that. So I guess when I look at this, I don't, there was a $2 million ask, I think, if I remember right. I gotta go back and look at the bill, in this bill. So, if I'm not mistaken, again, the first responders would be eligible for the scholarship fund that I'm creating in my online gaming bill, which make this kind of a duplicative expenditure. We'll be voting this Thursday on that bill that allows, with an OTPA recommendation coming out of the committee, that would make the two-year college free for New Hampshire residents. So I guess I'm a little concerned about this earmark. We talked about a little bit of problems, some collective bargaining agreement issues that might occur out of here again, where we're earmarking funds outside the CBA for benefits to first responders that may be covered by a CBA, and I'm not sure we can do that. So.
Any other discussion? Senator Prentice.
Thank you, Senator Ward. Senator Lang, thank you. I would prefer to keep these two separate for now. I see where there's a potential for crossing, and I'm pretty sure I remember a conversation, or during the hearing. I should go back and look at the hearing report, but where between you and Senator Waters about some potential to bring this together, because this does have a fiscal note attached to it. But I without him being part of the discussion, the commingling of it, and how your bill is funded versus this bill is funded, I just want to keep them separate. That's my 10 cents. Okay.
I agree with Senator Prentice.
What was the agreement?
We're
Hold on.
keeping it separate.
So, Madam Chair, remember, there's also a couple of things. There's an amendment by Senator Waters, which
Yeah.
was
Yeah,
290S, and the amendment needs an amendment. Because under line G, if we to move forward, that the state police union is actually the Troopers Association, not the state police union. So to be specific, who has the authority?
Senator Prentice?
Senator Ward, is there any reason that we can't invite Senator Waters back, or just ask for further clarification?
Sure. We can do that.
Yeah.
We can
that's-
do that.
I want to make
What is
sure.
that first Tuesday after our break?
Yeah. So we need to be done by the 9th because it has an FN, right?
Okay.
So, yeah.
Do to hold this one off until the 7th, whatever.
Let's get Senator Waters either back in here or talk to him. I'd be happy to.
So, Madam Chair, if I may, we could also re-refer this bill, right? To see what the budget process happens like and take it up next year. Right? So again, we could,
We can do
I don't necessarily disagree with the concept of the bill, but I'm trying to understand, again, we have a budget process and a fiscal process going on right
Mhm.
now. And I know that there were some initiatives put in by the governor relative to education as well. So I guess I'm hesitant to pass it, knowing that, although I don't disagree with the concept, but the $2 million ask and the fire academy ask is a lot.
Mhm.
Senator Ward, may
Yes,
I?
Senator
So
Prentice.
I'm not rushing to pass this. I'm rushing to actually hold it to get some clarification.
Okay.
And I also just, if I may, I sat on the Fire and EMS Recruitment and Retention Workforce Committee established by Commissioner, I want to say Commissioner Flynn, God rest his soul, but it's actually Commissioner Quinn last summer. And this was one of the recommendations that came out of that. Looking at different ways to invest in our fire and emergency medical services community. So, as well as the law enforcement is involved in here as well. We didn't take up law enforcement in that particular study. It wasn't a legislative study committee. It was established by the Commissioner of the Department of Safety under his authority. So my point is, there was this whole, robust conversation over the course of the summer that came out with specific recommendations because we are lacking, we are lacking fire and EMS professionals in our communities all over the state. And this was seen as one of the ways, looking at things that other states have done to incentivize them to come into the profession and to stay in the profession. And it does have an alignment with the work that Senator Lang is doing clearly. So that is why I'm not in a rush to pass. I'm in a rush to hold and the work, just to get some clarity, talk to Senator Waters further. And the worst case scenario, reflective of the budget process, is that we could, if we all end up agreeing with this, we could have it tabled. We could bring it to the floor. We could have it I don't think that's the worst case scenario, to look at how the budget process works out, see if there's a place for this there. I mean, that's,
Okay.
so there's a few different, there's like 5
Right,
balls in
right.
the air. I'd like to bring Senator Waters back in, and I think all those other pieces are part of consideration. And I'm happy to lead the conversation with him, with that MMA, and that's it.
Well, let's rush to hold this one then. Okay, so we'll hold
No
that.
rush to hold.
Rush to hold. How about the catalytic converters?
That's transportation.
How come it ended up in my education thing here?
We could vote on it.
We already passed.
So why is it doing it here? No, no. That amendment, and it's just the amendment that ended up in the wrong spot.
Maybe convert.
I do have copies of public committee.
We have a whole bunch of, for lack of a better phrase, incentive bills or grant bills or workforce bills.
Yep.
They're all of similar topic, right? So, I don't, well, we also have, can we do 151 yet? I forgot where we were on that one.
I'm still looking at 217.
You had an amendment.
I have an amendment for it. Why do I have an amendment for it? And I can send it back up there. It's hereby appropriated some 1 million.
What about 140, establishing a program for the recruitment of educators?
Okay, we can do that.
There's Senator Carson
Yes.
and Senator Benton. We're also to recruitment.
Yes and no.
Yes, and no. There's a part that crosses and a part that doesn't. Where's Benton? Well, the early underserved educator incentive program. So it's incentive versus,
Which one are we looking at?
so there's 217 and 140.
Okay.
Mr. Chairman, which bill we gonna talk about next?
Which one do you want to discuss? The thing is that when we're talking about development grants, in the governor's budget, I know that he's planning on money to help professionals, not just teachers, but other professionals who are we are in dire need of, like nurses, biotechnology, teachers. There will be a program set aside to help them relieve some of the death problems for them. I know that's happening. I'm sort of reluctant to do all these other things in the meantime before we know exactly what's in the budget.
That's a good point.
Yes, Senator Prentice?
Senator Ward, thank you. Great point. Is it appropriate to re-refer these bills so that we keep them in the pipeline? Once all the details are fleshed out on the budget and we know what is funded that will cross into these areas versus what isn't, we can come back and revisit them?
Probably.
Okay, that's just one potential strategy.
How does everybody else feel about it?
Yes and no. Sorry. Yes and no. I know there was a similar bill to mine, 217 in House, and they retained that bill because they knew we had this bill here,
Who retained the bill?
the House
House,
Education
okay.
Committee.
Well, I have discovered that some of the bills that we have been getting here are identical to what has, well, I should say almost identical, because a couple of times there have been a word change. And they have been sent here and they have been sent to the House. So you have two committees discussing the same bills, hoping that maybe it will pass where one place and not the other, which is sort of I think, a waste of time, but our discussion time, but.
So Madam Chair, are we talking about the group of bills, 140, 217, and 218? Right, so we have 140 is the establishment of the recruitment for educators, and then we've got establishing rural and underserved educator incentive programs. And then we have establishing an early educator professional grant program. These are all incentive
Right.
type of programs that are, again, I think we're going to be talking about in the budget process. Because we know the governor's made significant changes in the funding formula and in programs for workforce.
Yeah, I like to see what's in the budget. I like to see what the plan is before we go ahead and appropriate all kinds of money everywhere. So I'll be happy to re-refer if that's the,
Do we want to re-refer all three? Is that the plan? I think, oh, sorry, apologies. I think there is a little bit of overlap. I think they all do serve a specific area with varying degrees of fiscal notes. So is the consensus, we're thinking refer all three of those bills?
re-refer all three other bills until we have some more information. Since I know that in the governor's budget, there will be something for underserved areas and debt relief and some other things. And I'd like to see what those things are before we go ahead and distribute our money that we may or may not have. So that'll sort of re-refer, we can always take another look at it. So I'm looking for a motion.
I wouldn't mind taking it. I wouldn't mind taking.
Keep speaking out of turn, raising my hand. Senator Ward, may
You
I?
can speak out of turn, yes. you may.
Okay. Senator Fenton, two of them are your bills. So
Will you give me till March 7th on those two bills? Is that a fair ask?
Yeah, we can't take them up until then.
Oh, okay.
Right. But
Instead of referring them right now.
wait,
So let's not take a
if we
motion
are
on them.
if we are re-referring them, they can just be re-referred until we take them up again. And I don't think that we're gonna know very much about the governor's budget and what his plan is for educational formula. I mean, I just read that he's totally redoing the education formula and changing the adequate funding for schools. And I like to see more about what that's gonna look like before we go ahead and have all kinds of grants and appropriations.
No, I totally understand. I meant more of not take any action today, but re-refer them next time we meet, just so I can see where they overlap.
Okay, I can hold them.
So, yeah, okay.
Do we hold these three bills? 140, 217, and 218?
It's worth giving the town sponsor.
So the hard part's going to be, I'm not sure we're going to have any kind of budgetary
We're
information by that.
probably not. It's
Yeah.
more fine from me. I apologize. I thank the committee for that.
And Senator Ward, if I may, once again out of turn. So part of what I'm hearing from you, Senator Fenton, I mean, the budget is of how the budgetary details flex into this are of great interest, I think, to all of us. But you want to look specifically outside of that at Senator Carson's Senator Carson's bill about recruitment and retention, and your two, one with underserved areas, and the other is the early educator. And it sounds like when we get to the budget part, there may be, for two of those, maybe not one, some solution that's going to be shared with us in more detail. But you want to look and find where the cross may be of these bills and bring it back to the committee. Is that what I'm hearing?
Correct.
All right, so there may be an opportunity to do something in a more consolidated manner or just re-refer.
What a beautiful way of putting it.
All right. No, I'm comfortable with that.
So,
Keep
we
touching
have
these pages.
no more education bills that we have to hear. So the next time we meet, there's going to be an executive session.
So what about 272, was that not submitted? Establishing a parental bill of rights in education by Senator Carson? It's the last
It's a
list.
late bill. Yeah. It's coming here?
But I don't know, it's on our list. And it's got an FN. So we'd have to hear it next week.
No, a week from,
A week from
2
now,
weeks from
yeah.
today.
We have to dispose of it by the 7th.
Yes.
But we have to
they're
have a
gonna
public
hear it on
hearing
the
before
7th,
that, and then we
and-
can exec it, right? So,
Should be a long day.
Yep, we may,
and there is
I
one,
may ask for some time in that afternoon on that Tuesday, because transportation is, as far as I know, is done and finished with. So we can have some extra time, so we don't have to make bad decisions because we don't have time.
and I think we also have one other bill, 151, we haven't exec yet, have we?
Yep. Relative to mental health education,
I don't have it marked as,
there's another FN bill.
Are we ready to vote on that?
And I think I had a question, is this going to be a subject matter that's going to be taught on a regular basis, or is it going to be taught on an occasional basis? And how is the mental health taught? You know, what aspects of mental health?
So
And
ma-
are the parents notified?
right, so Madam Chair,
Right.
the real effective section of this statute is at the end of, page 2, 13 through 23, right? So we're talking about the fact that, a mental health curriculum in paragraph 1 includes consideration of bullying, cyberbullying, suicide prevention, biological, social, and environmental influences on mental health disorders, including but not limited to anxiety, depression, panic attacks, obsessive compulsive disorder, attention deficit hyperactivity disorder, and unhealthy behaviors, relationship of mental health and substance misuse, mental health coping strategies, including personal practice relationships and mental health treatment information, and skills to recognize personal mental health issues in themselves and in peers. So, I mean, that's really the focus of the bill, is to add that kind of conversation. I think when we look at, we had NAMI submitted the information on this. For me, the most important statistic is the fact that suicide is the number 2 cause of death in our teenagers. And to turn a blind eye to that is problematic for me.
And bullying is up, and bullying is a big part of kids committing suicide. They just can't deal with it.
So I think it's important to think that this isn't a clinical thing, right? Again, we're not diagnosing anybody with anything. I think the goal here is to teach kids how to recognize behaviors, and so that they can take action before they become a statistic.
And if I may, Senator Ward, just to follow up, and is that, New Futures letter, it said this would emphasize the importance of mental health for youth and teach them the basic tools that could help reduce the stressors they face in everyday life. I mean, the point is to take a vehicle, in my mind, that we already have available to us in education and make mental health education part of that, because we recognize what an influence this is having on, on school-age children. And not the best influence. I think we saw these cases happen in New Hampshire, but I happened to catch one on, I think it was the evening news of a young cheerleader who looked like she had everything to live for, and like on Friday night was cheering with her colleagues, and on Saturday she took her life, and it showed that she had, whatever struggle she was having, she either didn't have the tools to deal with it, or couldn't even recognize how deep under it she was, and nobody else knew. So you've got this place where we can intentionally insert this and I think impact the lives of children in New Hampshire, my opinion.
So I guess I'm thinking too, from a parental standpoint, I don't think we have anything in here that would, and we didn't have any parent testify either, as far as what their thoughts on this. And I don't like the first section of this. Are we planting thoughts? The other thing that I really, and would probably would never ever get to it, is what's at the root of the bullying? What's at the root of the mental health, and what is it that actually is going to be taught and shared? I don't know. I have some issues with it.
It does, if, Senator Ward, if I may, and I think Senator Lang already talked about this. So the Department of Education can adopt rules, directs them to adopt rules that would identify the provisions of mental health curriculum. I mean, it covers in here, I believe, what they would be writing rules related to the educational component of this. That's what I think.
But just looking at section 4C, there's an awful lot of stuff that I'm assuming the teachers or guidance counselor or somebody's gonna have to cover. And sometimes I think it's just too much for them. But is there something like basic mental health?
So,
And if they're
Madam
gonna
Chair,
have-
so again, this isn't a clinical setting, right? So this is about some basic coping techniques and identification techniques is the way I look at this bill. I mean, the findings section, I could strike the whole thing. I could really care less.
But what it does is what matters.
But what it does is what matters, right? So I'm fine with a committee amendment that strikes the entire finding section and just step into the statutory section that says, again, mental health coping strategies, including personal practices and relationships, mental health treatment information, again, telling kids where they can go. I know we passed a bill not that long ago that
Student ID.
put on the back of the student ID, the suicide hotline number. Again, I think that was a step in the right direction. This is, again, just kind of calling out to kids that say, these are the symptoms, right? For lack of a better phrase. And if you're experiencing these, don't come to me. I am not the guy that can help you as a teacher, but here's the information, the people you can go to, whether it's the guidance counselor, the school nurse, or whether it's a mental health professional. Giving the kids the understanding that there is an alternative. So I'd be fine if there's a committee amendment to strike the entire finding section, even though it has no effect on law, so to speak, and just start with page 2, line 5, and make that the new bill.
Yeah, we really don't need the finding section.
No, we don't.
So
that?
I see that,
Findings.
I'm fine with taking that out. But this is an FN bill. I don't see any reference to any appropriation.
So
There's-
the FN, the fiscal note just says indeterminate increase, minimum of $100,000 per year. And I'm assuming it just has to do with the effort that DOE is going to have to put in to develop rules and go through the rulemaking process to make sure that the curriculum that they create that would be used for this purpose is there. But I don't know that they have to hire anybody new, but there will be some time and effort put into this by the DOE.
But
Is there anything now in the school system that is sharing with the students?
I
If they-
don't know what the curriculum looks like. I'm sure that
Yeah.
some places they talk about it, but I mean, we have the suicide prevention and we have bullying and there are bills on bullying. The question is that I just saw on television the other day, a kid being just kicked. And we have a rule on it, but it doesn't seem to
Yeah.
do anything. Nobody's watching it and taking responsibility for it.
So will this supersede that then? That they're already learning about it, they know about it, but how is this
I
going
think what
to?
they're doing here is adding more.
So again, I think the difference is that we'll take the girl from New Jersey, right? That ended up committing suicide because of being bullied, right? And so schools have adopted a zero tolerance policy, right? But the question is, what happens to the victim of bullying? Right? And this is, we've taken a zero tolerance policy towards the perpetrator. This is talking about the victim, right? And what happens when a victim is dealing with things like this, and do they get depression to the point where they commit suicide, like the girl from New Jersey, and making sure that they're aware of putting into statute a place where students know that we can provide them the education necessary to cope and maybe help resolve those mental health issues that occur rather than committing suicide.
And I do think in a situation like this, the parents should be involved, and they have to know what's going on with the kids. I agree.
So if I,
Do I
again,
have
if
a
I,
motion? You wanna
well,
Exclude,
I don't see where, sorry, go ahead.
so the first is I move to amend and strike section 1, number 1, 2, 3, and 4 from the bill. All the finding sections, just strike them out. They're superfluous.
section 1 is findings.
Yep, all of section 1 and findings.
Okay,
And just go to adequate education criteria, mental health.
okay.
Can we have a portion in there where it talks about the parental notification?
So, well, let's get to this motion first, and then we can see if we can get the next motion.
So I'll second that. Second
Strike-
Senator
Strike
Lang's.
section 1, findings. Okay,
I'll be honest, Madam Chair, just speak to my motion. It takes the political out of the argument. So by striking that section and sticks to the kids, conversation around the kids.
So we've got the bill, take me back, because may I? Okay, I know, but the underlying bill, did we have a motion on the underlying bill?
No.
Okay, sorry, that's why, yeah, like, wait a minute.
no, I'm waiting for the, adding the parents have to be involved in it.
But
We don't do one motion at a time, so
Yeah.
first I would amend by striking section 1, and then
Yes.
another amendment if you want to add.
All those in favor?
Aye.
Of
Aye.
striking that. You got that, Pete? Strike findings.
Madam Chair? If we could hear from,
Yeah, Senator.
is it your education, right? No. All right, so I guess I'd want to know from the agency if there is already a parental notice requirement for health classes and what that looks like.
thank you. That's why I have my hand up, is I believe that, no, but I believe, that's what I want to know, because I believe that there already is. Like,
So for the record, Diana Fenton with the Department of Education. So if you look at RSA 186,
hold on.
see, or just 186? I get it, 186. 186.11.
Hold on, bring her up.
And that's the law that has the survey opt-out, opt-in. That bill is always coming forward every legislative session, so you think that I would know the law by then. But that's one paragraph of 186.11. If you look at 186.11.9, maybe, they talk about controversial curriculum, health education, sex education. There is parental notification and 2-week notice provision in that section. So if this committee wants to do a cross-reference to that, make it clear that it has to fall within that notification period.
I think that should be in there.
186:11, maybe.
That's duties of State Board of Education.
Yeah, that's what I do, is it,
I will never leave my book in the car again.
Give me
I
a
want to use
second.
my computer.
I have my laptop. I can find it, but it's
Senator Lang, do you want to put this amendment forward and we can bring it back or not?
Give me 1 second.
Well, it'd be nice to get it, if we're that close to it, to just get it it's done.
Right, give me a minute to look up this
There's
section
another
about
F and the-
parental notification.
Oh, look at that, we have them right here.
All right, so actually, I think we've got something here. 186.11, 1XC requires.
The 186:11. Duties of the state board. Oh, hello. Oh, I wrote that. It's brilliant. That was written by a really good lawyer.
I guess so. huh?
Yeah, just put that.
I
on the
know her.
record. Yeah, I do
Alright,
too.
Okay.
So 186:11 is always being amended. So we're gonna go into the pocket part. This is what they teach at law school. Okay.
That's all put in there.
Hmm.
So there's a law that was passed in 2017. I just want to make sure that it hasn't been repealed. And I do not believe that it has. That says that it amends this. So there is a provision where school districts adopt a policy allowing for an exception to objectionable course material. It was amended, 103 became effective. The amendment requires school districts to provide 2 weeks advance notice to parents or legal guardians of curriculum course material used for the instruction of, well, this is human sexuality or human sexual education.
So if I may, I'm
That's
gonna jump off what you said.
Go.
So it's RSA, again, just to be clear, it's RSA 186:11. It is entitled, as Senator Lang correctly pointed out, Duties of the State Board of Education. But if you look at 3 particular provisions, so there's Roman numeral 9, little b, health and sex education requires school districts to adopt a policy allowing an exception to a particular unit of health or sex education instruction based on religious objections. That's one provision. But then there's 9C, requires school districts to adopt a policy allowing an exception to course material based on parent or legal guardian's determination that the material is objectionable. That's really where I think this committee is going to focus its efforts. So the other one, 9D, is the survey provision. The survey provision, every legislative session comes up. People want, when it's opt-in, they want to make it opt-out. When it's opt-out, they want to make it opt-in. So this committee has worked on and has reviewed 9D. Where you want to focus is 9C. Schools have to have that policy requiring the parent or legal guardian to notify the school principal or designee in writing of the material to which they object. 2 weeks advance notice. So this issue has actually come up recently. We've had parents contact the department with concerns about some curriculum being used in their child's school. And the school did comply with this 2-week notice provision, did provide for alternative curriculum material. And so I think in looking at your amendment, you could do a cross-reference to say that this particular curriculum falls within this notice. And that way it's not ambiguous, if that helps at all. So 186:11.
So if I understand, if I may, Madam Chair. So if I stand right, again, we could just add a section under here that just says that, again, the provision of the mental health of the statute shall comply with RSA 189.11(9)(c), which is
I
the
would say
notification
it would-
requirement.
It's
Falls within the notification,
subject to.
subject to the
Subject
notification
to the
requirements.
requirement provision of that. Recognizing, however, because I do think, generally speaking, the legislature it behooves the legislature to be exceedingly clear, because when it is enacted in the field and by the department, that is where the questions and the ambiguousness of it arise. And so you never know the problems of the law until you apply it to a fact pattern. I can tell you that from my criminal experience. I can tell you that from education. That is where all of a sudden you say, oh, there's an issue here. Recognize, Senator Lang, that the problem that you will have, and it's a fixable problem, but when 18611 Roman numeral 9C is brought forward in upcoming legislative sessions, it might change the nature of what you have written. That's fine.
Right, so
But-
incorporating by reference problem, yeah.
Exactly. It's a collateral consequence. However, it behooves this committee and any committee, if that is a curriculum that this committee feels needs to be subject to that parental notification, and that's what you want school districts to do, school districts will appreciate you telling them that, because inevitably we will get questions as to, well, do we have to do the 2-week notice? Do we not have to? And what happens when that occurs is you have inconsistency across the state. And that's where it becomes problematic. And Jerry's not here to back that up, but that's where you'll have those inconsistencies, and that's where parents say, well, this was given at this school and they gave a notice. Why not at my school?
Okay,
So, Madam
Okay.
Chair.
where should we put it?
So, right, so I guess what I would do is I would move that we, after section 5 on line 24 of the bill,
I was looking at that.
we add number 6 that just says the provisions of section C, which is the implementation of the mental health curriculum, shall be subject to the requirements of RSA 189:11, 9-C, which is the notification requirements.
I think that's a good place for it.
So I'd make that motion that we add that to the committee amendment.
Any further discussion on it? All those in favor of adding
Is the
that to
underlying
the
bill done yet?
thing? What?
Sorry, just process-wise, because it's been going on. Senator Ward, have we
We haven't made a motion on the bill.
okay, so should we go for motion on the bill and then do these amendments that we've been
We
working?
just passed the amendment, then I'll move OTPA as amended by the committee amendment.
Okay. How much coffee do you drink?
A lot.
You're killing me. Maybe I shouldn't use that word. Oh my
I
gosh.
get you.
Yes.
Well, this is a committee amendment they're we're making the amendments, and when you finish making.
And then bringing it in as part,
Then,
okay.
then you
thank
go back to the full bill.
You know, for the purposes of, making sure this gets into the classroom one way or another, you know, I'll agree to, I think striking the findings makes sense because that's an area we couldn't agree. I think, you know, the question is, does mental health education belong in the classroom? And I believe that it does. You know, I've had a child in school. I've been engaged in what's been happening in the school system, and I'm not worried. Yeah, I just want to be. I don't know.
Madam Chair, for me. So again, the current amendment that I'm asking for just makes it that there's a notification requirement and an opt-out provision for parents who don't want their kids to have this classroom for whatever reason, similar to our human sexuality classes, that we allow them the same opt-out notification provision. So if for some reason a parent finds it objectionable, they can have an opt-out provision. That's all the Second Amendment does.
Okay, and that's gonna be
Be number 6,
6.
and then we'll renumber effective date to
And then
number
7
7.
be the effective date. Okay. Now, that's the Second Amendment to this bill. You made a motion.
Made a motion, Carrie seconded it.
Okay. Any further discussion on this? If not, are you ready to vote to accept that amendment? All those in favor?
Aye.
Aye. Okay,
So Madam Chair, I move Senate Bill 151 as amended by the committee amendment that strikes section 1, adds the notification provisions. And I move OTP as amended.
TP with committee amendments. Okay? Now, do we want to
Got a vote?
vote on the OTP with amendment on the underlying bill?
Aye.
And all those in favor?
Aye.
5-0. Do you want to put this on consent?
Move for consent, Madam Chair?
I'll second it. It's 5-0. All those in favor?
Aye.
Do you want to take this up?
Absolutely, I will.
Okay, I think that finishes up for today. You can get a head start up north. Okay. Well, thank you. I need a motion to get out of executive session.
Second?
All those in favor?
Aye.
We are out of executive session.
Does that clean that up?
Yeah.
Gone upstairs with house transportation, still listening to my driver's ed bill up there.
Oh, good. Okay.
My fourth attempt.